Okay. All right. So we are going to move to our final panel here. We are very grateful to all the faculty who joined us on very short notice for this panel in light of recent events. Preliminary thoughts, very much stressing the preliminary there, on legal issues relating to the Maduro seizure. So it's going to be a very kind of informal panel. I think each of the professors is going to speak for a couple of minutes to share some initial thoughts, and then they might want to kind of react to each other a bit, and then we are definitely going to save some time for questions from the floor because it's just that kind of thing where people may have, comments in the form of a question, as they say.
I guess I start. Yeah. So, I just have a few quick comments. I recently was at the Department of Justice as Principal Deputy in Antitrust Division, but I happen to also know a thing or two about international law, and so I think I'm asked for that reason rather than for my DOJ experience. But I do know the actors, some of the key actors in this matter, and I have a great respect for Todd Blanche, and I think that he's been a career prosecutor, and I think we should take his comments seriously. I have three comments. One, the Venezuelan people are celebrating. Don't miss that fact from what we're hearing in the U.S. commentary. Nobel Peace Prize laureate Ana Machado on December 10th gave her speech in Oslo. She found a way to get out of Venezuela and gave a speech in Oslo. And her speech said, "Venezuela will breathe again. We will open prison doors. We will see grandmothers settle children on their laps again. We will see our students debate ideas again. We will hug again and fall in love again and hear our streets filled with laughter again. All the simple joys of the world taken for granted will be ours once again." And then in the immediate aftermath of the Maduro abduction, she posted a bunch of stuff on Twitter, but the freedom of Venezuela is near, and soon we will celebrate on our land. We will shout, pray, and embrace as a family because our children will return home. She also said, given Maduro's refusal to accept a negotiated exit, the government of the United States has fulfilled its promise to uphold the law. I talked to a friend that had worked in Venezuela for 2 years with exchange students, and I said, well, what would be the split in Venezuela about Maduro? Would it be 80-20, 90-10? She said 100%. 100% of Venezuelans are absolutely thrilled that this is happening. So that's the first thing to say, is that this, from the Venezuelan perspective, they're absolutely celebrating. The second thing I will say is that from a prosecution perspective, a prosecution of Maduro, there's not much doubt that the concerns about international law violations will not be a major factor. He will raise the illegal capture, and he will raise head of state immunity. Fortunately, there are case laws that provide precedent about that. They're not all up to the Supreme Court level, but we have a pretty good idea from the Noriega case and the Alvarez-Machain case that head of state immunity, where the United States has not recognized, both under the Biden administration and under the Trump administration, has not recognized Maduro as the head of state. In fact, Biden administration called Gonzalez the president-elect, the one that won the election but didn't get to sit as president. So he will not be recognized as head of state under in U.S. courts because recognition is for the executive branch. And then secondly, with respect to illegal abduction, as a jurisdictional restriction, the Alvarez-Machain case, I think, just settles the answer. I mean, it's almost no question whatsoever. The only possibility is you try to argue that the extradition treaty between the Venezuelan and the United States is somehow different than the extradition treaty between Mexico and the United States. And I looked at that in 1922, and there's no real difference. And after Alvarez-Machain, the Venezuelans objected vigorously to the Supreme Court's ruling in Alvarez-Machain and said, we need to amend the extradition treaty with the United States, and they never did. So there is no change to the extradition treaty between Venezuela and the United States. Clinton administration signed an MLAT with Venezuela in 1997, Mutual Legal Assistance Treaty, and there was no reference to any modifications whatsoever to extradition. So I don't think that that is a major concern. The issue of whether or not it was an international law violation, I think there's two key questions. Could be three, but probably two key questions. Has international law has the international law community ever resolved this question before? Has there been international law commentary about this? And the answer to that is yes. No one's talking about it, but the Eichmann case is the case that is the best precedent for international law statements about illegal abductions. In 1961, the Mossad abducted Adolf Eichmann from Argentina and then tried him in Israel for crimes that he committed prior to the existence of the State of Israel. The United Nations Security Council issued a Security Council Resolution 138, and Security Council 138 basically, I think, is the best statement about this issue, and it specifically says, and again, the United States signed on to this resolution, declares that acts such as that under the consideration, meaning the kidnapping of Eichmann by the Mossad, which affect the sovereignty of a member state and therefore cause international friction may, if repeated, endanger international peace and security. So they fudged the question. They didn't want to officially declare that it was a violation of international law. And then 3 months later, Israel and Argentina, and also, critical, requests the government of Israel to make appropriate reparations. That's what the Security Council resolution said. What was the appropriate reparations? An apology. And so Israel issued an apology to Argentina. There was a joint communique that was signed between Argentina and Israel in August of 1960. And they said the violation is an injury to the state of Argentina, not to Eichmann. And now that Argentina is satisfied with the resolution of the case through the communique that they settled, then the matter is settled for purposes of Eichmann's prosecution. So that is, I think, the best international analogy. Obviously, the Noriega one is also relevant, but those are pronouncements in the domestic context. In terms of international, I think the Eichmann case is the best case. I'll stop there.
Well, thank you very much for Federalist Society for put together this, for inviting me, and I really want to stress the first thoughts because I have been having a hard time to putting together the ideas of like what I do really think about this. So I'm going to step back a little bit just because in a lot of the conversations on the hallways, people have asked me like, what are the international norms that people said that we are violating? So I'm going to play like the devil advocate saying like, okay, trying to explain which are the norms that have been invoked by people saying that we have violated international law, and then try to make a case from the human rights perspective, that's my field, why we still have a case here. So public international law is grounded in territorial sovereignty principle. And this principle aligns with the idea that many of us share here, that is subsidiarity. Like we want the people of the country to decide on their own what to do with what happens in your own state. And the United States Charter, that is a treaty that the US has ratified, establishes a series of principles of how do we understand this sovereignty. And Article 2 is the one that people are like bringing up today. Establishes that the United Nations is organized on the principle of sovereign equality. So like the US is equally important than Venezuela or than any other country. All members shall settle their international disputes by peaceful means. All members shall refrain in the international relations from the threat of the use of force against territorial integrity or political independence of the state, or in any other manner inconsistent with the purposes of the United Nations. So yeah, these norms try to establish like an international rule of law that it's very different from just the law of the powerful or the iron laws that have been cited. So it's true that we don't have international enforcement mechanisms, but that doesn't mean that they're not law. Moving to the events of this week. So thus sending United States military into a territory of Venezuela, detaining the de facto president of the country in an operation involving killing 70 people, go against like this Article 2.4 of the UN Charter. Well, there's a good case to say it does, okay? But, and here's where I think we need to like encourage, and I agree with like everyone in Venezuela is happy about this, so like we have to find a solution. and not just say like, okay, we're like Article 2 doesn't allow us to do anything. So the United Nations Charter was drafted also at the same time that human rights law was developing. And that means that the sovereignty that we have understood until 1945 it stopped being an absolute sovereignty. Like, sovereignty had limits. And the limits are precisely the respect for human rights. So the states don't have the ability to do whatever they want within their territory. Now that we have human rights, the states have obligations to their own citizens within their territory, and the international community can enforce those obligations. And it's precisely one of the purposes of the same United Nations Charter that everyone is citing, saying like, oh, you breached the United Nations Charter. Well, the same United Nations Charter in Article 1 establishes that one of the purposes of the United Nations is to promote and encourage respect for human rights and fundamental freedoms of all. So the United Nations has those two complementary goals. Like, yes, peace and security, but also has the goal of protecting human rights. So what do we do with the human rights of the Venezuelan people that have not been respected for 30 years? So up to now, international law trying to balance these two purposes and principles has said, okay, all international human rights law requires the willingness of the state. So the states are bound by international norms, by international human rights norms, if they ratify the treaties, if they accept the jurisdiction of the international courts. The willingness of the state is always necessary, and I agree, and a lot of people probably here agree that it's good, that the state will matters, and if you have been following the news, just yesterday there's a presidential memoranda from President Trump that was circulated yesterday, withdrawing the U.S. from a long list of international organizations. So we are not funding and participating in many of these international organizations anymore, because the will of the state matters. But the big question is, okay, what do we do when a state simply is not willing to protect human rights, right? So what does the international community do? Just sit back and do nothing because, Article 2 of the UN Charter doesn't allow us to do nothing. And this is what happened in Venezuela. For 30 years, the regime of Maduro oppressed their political opponents, torture, murder, deny free elections, prohibit independent means of communication, expropriate private property, created immigration crisis of 7.9 million people. And also, the regime has defied international law. So now they're invoking it, but they have breached it too. And I want to bring one case that probably people are not aware here. There's this case that in Chile, there was a kidnapping and murder of a Venezuelan that was in the position of Maduro that took place in Chile, and it was ordered by the Maduro regime. Okay. So what options do I see from the international human rights perspective to justify that the US gets involved? There's one principle that I think it could be invoked, that it's called the responsibility to protect. It was developed in 2005, and it allows the international community to take action, collective action, to protect the populations from genocide, war crimes, ethnic cleansing, and crimes against humanity that is happening in a different territory. So what's the limitation of this responsibility to protect? The practical problem? It requires the authorization of the Security Council, and right now, the Security Council, with the veto power of China and Russia, will never allow an international intervention in Venezuela, because they have their own interest in what's happening there. So I believe that some modified version of this responsibility to protect would help justify the intervention the U.S. is taking in Venezuela. But I do think it matters that the justification is not only based on U.S. interests. Okay, so in the eyes of the rest of the world, it sounds like the U.S. For some remarks, it sounds like the U.S. is like have economic interest in Venezuela, so it's just like going to explode the oil and it's going to take profit from this. I don't think that's the only reason why they're doing it, but it's important that it's said there that there is a international human rights concern or a human rights concern, and that's why they want to help the Venezuelan people. And I think another way too that I think Roger already mentioned in some way is another way to justify this intervention would be like bringing up the consent of the real head of state, that is Edmundo Gonzalez, the president who was elected in the elections that were never recognized, and say, well, if this person is in favor of this and he asks the U.S. for help, well, is the consent of the state, the real consent of the head of state that is involved?
Thank you. I thank the Federalist Society for having me here. Whatever Lee Otis asks me to do, short of a violation of internationally recognized human rights, I will do. Just a word about international law. I teach foreign relations law. I'm a little bit of a skeptic of the broad vision of international law that's just been articulated. We have to have respect for international law, but happily it doesn't become part of U.S. law until we make it part of U.S. law. And we haven't, and that's Packet Habana. It goes back to a long history. Sure, we should interpret statutes that are ambiguous so as not to violate international law, but international law in this area is not stated at a level of particularity that it would even be able to trigger that canon of construction. It's hortatory. It's deliberately hortatory, and it's a good aspiration. But it's not clear to me that we can predicate any legal restriction on this prosecution on that basis. And I think you agree with me on that, Ryan. I may be wrong about that. On Noriega for a moment. Noriega's on all fours, except in two minor respects. He was arrested on drug violations, and by the way, he repaired to a church, I don't even know the story about this, to get shelter from the church's
Holy See,
auspices.
the Holy See Embassy, yeah.
Yeah, was the embassy? But
The Embassy of the Holy See, yeah.
no, we went to a church to get,
Am I right?
I'm certain, anyways. The embassy was run by a clerical organization?
I think the Vatican Embassy, but
Vatican, I'm sorry, Vatican. That could be the Vatican Embassy. And he was cowed out of it because they played raucous rock music, and he gave up. It's a really interesting. If we're looking for alternative means of coercive force, I think that was a good one. So the only two distinguishing characteristics of Noriega, I know the Supreme Court didn't pass on it, was a pretty good decision by the District Court in Florida and affirmed by the 11th Circuit. The only two distinctions was that he wasn't actually a head of state. He was never recognized as a head of state. And there was a period of time when we recognized Maduro as the head of state. That's one factual distinction. Secondly, as in the Barbary pirate situation, he declared war against the United States. So you could say this was a purely defensive action. And I don't know if that's going to happen again, because both in that context as well as the Noriega conflict. Other than that, it's on all fours. I want to mention a doctrine that was implicit in what Ryan had to say, Kerr-McGee. In fact, bringing a person to this country in violation of international law or in violation of our own Fourth Amendment, the Supreme Court has held at least two occasions that does not prevent the prosecution of the person. I had a student really into this issue. There's a case in the Second Circuit called, I just forgot the name of it, where the Second Circuit said if it really shocks the conscience, it might. Toscanino, I think the name is the name of the case. Jide, am I right about that? Toscanino, but it had no legs. No one has followed it. Because when do you know when something shocks the conscience? In any event, how Maduro was brought to this country will not affect the prosecution. That's Kerr-McGee. I don't see any force to overturn that doctrine. So, contrary to what you're reading in the papers, whatever international law has to say about this, it's not going to prevent the prosecution. And the Supreme Court would have to overturn Kerr-McGee, which I don't see happening. I don't see district court judges doing that either. So I think the prosecution, I don't know precisely how difficult it would be to bring the prosecution. I just don't know enough about the facts. That'll be interesting. But I don't think head of state immunity nor international law is going to bar the prosecution. Other things may. Now, history, we're all creatures of history. I don't like the idea of the president being able to go into another country and use military force without some degree of congressional oversight. But we have a history that goes back to the Barbary pirates and throughout. I mean, I can cite to you 150 examples of it involving lethal force by the president's forces that has not been struck down. It's not simply been rubber stamped by the Justice Department. This has been the clear and consistent position of the United States. So I just don't see how we can say, well, that history is all wrong because of Maduro. But I'm putting aside the fact there were beneficial outcomes for the Venezuelan people. I just hate to say it. On this one, the president, despite the way he's doing it, and he does it in the worst possible way. And I don't want to support Trump in anything when I'm supporting him, because he does it in the worst possible way. He doesn't believe in the importance of respect for the forum and respect for the process. Whereas Obama and Biden did the stuff, but they have 19 pages about all the different factors that they consider. They came out the same way. There's got to be respect for the process. He doesn't believe in it. It's a different style of governing, and he doesn't have any people even help him with the rhetoric that he's using. So there's a problem with the way he's doing it and the way he speaks about it. So my concerns are, and again, we're in Louisiana. I reread Huey Long's history. The guy started out as a lefty. I mean, I think that AOC and people should really embrace Huey Long, but he went too far, and that's the problem I have with Trump going too far, or the president's going too far. There's at least a duty of consultation. Contrary to what our vice president said, he apparently did not get the optimal legal education at Yale that he would have gotten had he been my student at NYU.
He was my 1L professor for Civ Pro.
That's right. I take credit for this guy. But, I mean, to say that the War Powers Resolution is a fake, I don't even know what that sentence means. But, it's true that presidents have said that some aspects of the War Powers Resolution are unconstitutional. I think they're referring to Section 4, which is a provision that says, if you don't do our bidding, you have to terminate your involvement. Do our bidding in terms of reports and all that stuff. I think that might violate Article 2. I think it's a close call. But there's a duty of consultation that I don't think plausibly violates Article 2. I'd like to hear what other folks have to say about this. And it's an ongoing duty of consultation. I think it's important to bring the Congress into it. I don't know if there's some systemic problem with keeping a confidence prior to the introduction of forces. If there is, we should actually impeach these senators if, in fact, they breach such a confidence. But there's an obligation of consultation before you introduce the forces. I don't buy the argument of another Yale person that there aren't hostilities here. That's how it was justified under Obama. These are not hostilities. They're short term, even if it involves, 200 planes, 7-month overtaking of the protection of no-fly zones. I mean, hostilities has some meaning. It's not entirely elastic. Even if Senator Javits said it's a little ambiguous at the edges. So I think there's a duty of consultation, and if these senators and congressmen cannot live up to a duty of confidentiality, that is the grounds for impeachment. I think they will. They will, and that's critical. It's critical because we have seen in a number of areas the Congress has just given up its role as an important check on the executive. I just did a brief in the Trump tariffs case because the president relies on the International Economic Emergency Protection Act. I think it's a violation of the delegation doctrine. I started out life as a Lyndon Johnson liberal, and I'm arguing for bringing back some aspects of the non-delegation doctrine. I don't know, Lee, if it's been my propinquity to you that is causing this derangement in my mind. But I think there's a problem with that statute because basically the president can do whatever he wants in the economic sanctions and in the tariffs area, and it takes a veto-proof majority of the Congress to check them. That's a real problem. That's a real problem for our state of affairs. So I want the Congress involved here, and let's have an enforceable duty. Now people say, well, you don't have to have this. You just have you check them at the pocketbook. You don't fund it. You know how we fund government now? We fund government in these omnibus bills. Everything is in it, and you don't veto it because everything will shut down. So it is not an effective check. I'd like to know your views on this, Roger. Cut it. All right. I'm told to cut it. All right. So I think we need to work this through some more on the process end. Thank you.
Thank you. I don't know if I'll ask the Federalist Society people whether it's too late to have a soundtrack, which would be Guns N' Roses, which, if I remember correctly, is the music that was played to get.
Is that right?
I think it was Guns N' Roses.
I would also have left the Vatican.
to get Noriega out of the nuncio's place. I'm not going to talk about the viability of the criminal prosecution. I think I largely agree with what's been said about that so far. Rather, I'm going to talk about whether the operation, given my very limited knowledge of it, and I want to stress that I'm a lawyer, so of course I know no facts. So I'm going to talk about that. I'm going to talk about the law. But given, and so you can just take what I say as assumptions about what the facts are on the basis of what I understand the facts to be, whether the operation to seize Maduro was consistent with the principles that the executive branch has developed over the last more than 100 years for presidentially ordered uses of force that are not pursuant to congressional authorization. And my answer is no. That there are two situations that executive branch lawyers have identified in which the president can say, yes, United States forces are going to be used on the territory of another sovereign without Congress saying yes. I also think Congress has not implicitly authorized this. I think that's an important question, but I think they haven't. And those circumstances are first when there has been some kind of attack on the United States territory, United States persons, United States assets, United States forces, self-defense and connecting to U.S. domestic law and international law. The Charter says no use of force contrary to the territorial integrity, political independence of any other state, but Article 51 cites the inherent right of self-defense, but it's a right of self-defense. That's the international law part. The U.S. domestic law part is the idea, I don't think it's right, but that's long been taken by presidents and executive branch lawyers, is that in response to an attack on the United States, the president can order at least defensive measures that maybe, I think most people would say, who's participated in this debate over time, that doesn't mean that the president can escalate the conflict, but it does mean the president can act defensively. The factual assumption I'm making is there was not an attack on any U.S. forces, any U.S. persons, unlike the situation with Noriega in Panama Operation Just Cause. More interesting is the theory that the executive branch has had for a little more than 100 years. And it goes back to 1912, a memorandum by the Solicitor of the State Department. It's especially interesting because the practice that the State Department memorandum was about was sort of trying to justify what had already been done and with a view toward things that might happen, including at the time a possible intervention in Mexico, consisted primarily of the United States landing troops in Latin American countries when there was some kind of civil unrest, some kind of disturbance, and protecting U.S. persons, U.S. assets. The theory that the State Department came up with then, and that I think follows through OLC opinion since, is that for U.S. domestic constitutional law purposes, there are uses of force that are not war, and therefore that are not subject to Congress's exclusive power to declare war. And that under those circumstances, thus short of war circumstances, the president's authority as chief executive, as person who makes and carries out the foreign policy of the United States, can involve the use of force, including deadly force, in the territory of another country, provided it is below the threshold of war. The term that President Theodore Roosevelt came up with for that was police action. They are also called intervention, interposition. The theory, and it's interesting that State Department memorandum primarily was concerned with international law. Talked about U.S. domestic law, some made the point I just made, but primarily was concerned with international law, and said, going back to an instance in the 1830s in which the United States was on the receiving end of this sort of thing, the Caroline episode, you may have heard of that, in which British forces came from Canada, crossed the border, Niagara Falls, to deal with insurgents who were being supported on the American side, seized the vessel, the Caroline, sent it over Niagara Falls in flames. It would have been great footage had there been such thing at the time, but the United States was prepared to admit that in principle there were circumstances in which one country could use force in the territory of another where the territorial state had not fulfilled its obligations under international law to, for example, suppress operations going into the other country, and that would not constitute an act of war. It was something below the level of war. That was the idea that the State Department and the Taft administration relied on. Yes, there are things that are short of war, and carried that over onto the U.S. domestic side. Interesting subsequent historical development, 1945, when the United States became a party to the Charter and Congress passed the UN Participation Act. The theory of why the United States could participate in Security Council operations without congressional authorization for each one was those were police actions. Those aren't war either. Well, that's not what's going on now. The Security Council has not been involved. Is it possible to say that, sort of under what executive branch lawyers have said for a long time, that what happened with respect to Maduro was below the war threshold? I find it extremely difficult to see how that could be the case. This was an incursion by U.S. armed forces to seize at least the de facto head of state and government of another sovereign against the opposition of the security forces of the other sovereign. The idea that that is not an interference with the other sovereign, that that's just the United States protecting its own nationals and assets, seems to me a very difficult argument to make. If the facts are, as I'm sort of assuming that they are, then what happened with respect to Maduro doesn't fit into that other circumstance that executive branch lawyers have identified, something short of war. Well, no. Seizing another country's head of government by an act by a military operation against the opposition of their security forces, that, for U.S. constitutional purposes, that's war. I also think, I take more seriously, I think, than a lot of people would, the possibility that Congress has implicitly authorized uses of military force. I think to some extent Congress has done so, and that's the reason that what often happens is consistent with the U.S. Constitution. The suggestion that this sort of thing is authorized, especially in the light of the War Powers Resolution, again, I think it is very difficult to make that claim. So as I say, based on what I know right now, I don't think that sort of the long-standing position that executive branch lawyers have been taking for many decades now about when the U.S. armed forces, consistent with U.S. domestic law, can be used in a way like that without the authorization of Congress. I don't think those conditions have been satisfied as far as I know.
So, can you hear me? Okay. So very quickly, I'm also going to shift gears again, and maybe not following up on John, and not maybe talk about the criminal issue, and also not talk about the war powers element. I'm going to be unromantic and talk about a legal issue that actually might result in enforcement against the United States, which has to do with the economic dimension of this intervention or seizure of Maduro. And I take the mandate that we're giving was legal issues relating to, and so I take the relating to very expansively, because one of the things that did come up is that the president mentioned that Venezuela, at least the previous regime of Maduro and Chavez, had been unpleasant to American investors and to American property interests. And there was an announcement that Venezuelan oil will be shipped to the United States and be disposed of for the benefit of the folks of Venezuela and maybe Americans. So one of the things that is interesting about this move, and this is where the legal issues come up, is that you may think, okay, that's sort of bluster. Maybe this is going to be tempered. By the way, it may be tempered quickly, not because of some, what I would call statutory issues, but constitutional issues under the spending powers, which is that Congress may say, look, you just can't get money from Venezuela and spend it as you see fit. That's our job. And I think I think the administration will back off of that a little bit. But here's a tricky thing. I do think it's very likely that the current vice president, interim president of Venezuela is probably in negotiations with the Trump administration and may make some concession that oil can be used and shipped to the United States, right? And as part of this deal, some of it may look like it is coercive, some of it may look like it's not done entirely voluntarily. I don't think there's going to be a legal way to resolve that. And I also think just lifting the sanctions, the pre-existing sanctions that have been on Venezuela for so long, may be enough of an incentive for her to say, let's do it. Now, having said that, one concern may be that this mechanism may be a way to remedy previous expropriations by Maduro and Chavez. And by the way, Maduro and Chavez are probably what I would call the popes of expropriation. They've done more to expropriate property than I think any regime has done in modern history, and they do it flamboyantly. Now, having said that, there are some issues. One is, in international law, using diplomatic protection or forms of aggressive coercion to deal with settlement of these kinds of investment disputes is strongly disfavored, and there is a proactive treaty regime, which is we have a bilateral investment treaty mechanism with Venezuela that displaces what I would call using diplomatic protection or coercion to settle these kinds of claims. The investors can sue Venezuela. They can sue Venezuela under investment treaty arbitration, and they have sued Venezuela. Now, having said that, one qualification. When you sue Venezuela investment treaty arbitration, by the way, they don't like being sued and they've exited ICSID, but the problem is a lot of their bilateral investment treaties have survival clauses. So even when they don't exit bilateral investment treaties or try to exit them, it's not very helpful because some of those treaties will run for another 10, 15 years. So they're still being sued. Now, after they get sued, they lose a lot. Mostly because they take and expropriate things very flagrantly. So they lose almost all the claims. But they don't like pain. So that's another, so you could say, okay, you can win, but you're not paying. Now, there's another little angle to this, and maybe you could say Trump is saying, I'm intervening to increase the enforcement, that is the monetary compensation. There's a slight problem with that. Venezuela is probably, with Argentina, two of the most sued countries in investment treaty arbitration. Argentina doesn't like paying, and I know this is not true maybe on the current Argentina regime, but previous regimes didn't like to pay. Venezuela doesn't like to pay, but Venezuela had a little problem. Venezuela has a National Petroleum Corporation, Petroles de Venezuela, which happens to run gas stations all over the world. And if you run around here in New Orleans and other places, you may run into Citgo gas stations. Right. And what happened is that when they bring claims against Venezuela in the United States, there have been allowances that say, even though this is owned by the Venezuelan Petroleum Corporation, we're willing to pierce the veil and say that Venezuela owns it, and you can attach the assets of those Citgo gas stations. So in the United States, folks who have sued who are investors are able to get collection from those Citgo gas stations. So if you have that, one argument may be you have a remedy, therefore using diplomatic coercion or protection, let's say by the Trump administration, cannot displace that remedy because you are able at least to attach those assets. So that's the first point. But then there is a second point where investment treaty arbitration may come back and bite the United States. And this is what I mean, or indirectly. Here's the problem. There have been announcements and suggestions that some of these refineries and oil things should be handed over and managed jointly by the United States and Venezuela primarily. But here's the problem. Over the past couple of years, to maintain these refineries, Venezuela invited a lot of Chinese investment. And in 2024 alone, there was over $1.5 billion in Chinese investments in these things. So now you may want to ask yourself, well, what do you do? The problem is that China also has a bilateral investment treaty with Venezuela. And that bilateral investment treaty protects it from expropriation. It has a fair and equitable treatment clause. It has an MFN clause that says, you, Venezuela, agree to treat us the same way you would treat your most favorite investment partner. If at any time Chinese investments get compromised or refineries get seized, even voluntarily by the current Venezuelan government in coordination with the United States, Chinese investors are likely to sue. And if they sue under investment treaty arbitration, I think their chances are very good that they will prevail. They can sue under an MFN clause, they can sue under the fair and equitable treatment clause, they can sue if there is any kind of force majeure requirement that says we're not going to pay you until this crisis gets resolved. They can sue and say that defense doesn't exist. One last thing, you may say, well, if they sue, are they going to get the enforcement? Now, Citgo operates primarily in the United States. It doesn't operate in Europe and some other places. They're probably not going to have a favorable reception if they try to attach Citgo assets in the United States. But one thing that I think they can do is go to Curacao, because there are a lot of Venezuelan petroleum assets in Curacao, and other European groups who have sued Venezuela have been able to attach assets there. That is one area that I think is coming down the pipeline, and if you think that this is somehow ethereal, there are a lot of American law firms who are actually signaling to the Chinese, we're here. We're here to represent you when the problems come down the pipeline. And so they've already signaled to them, here are the likely issues that are likely to come down with the Trump administration, and here's how much we will charge you. So what happens is that you should just be aware that this is probably one area where we're going to have problems. Now, the only caveat is that if there is a claim, they are going to make claims, and the plaintiff and the defendant will be the Venezuelan government. It will be the current Venezuelan government. But if they're collecting damages from the Venezuelan government for violation of the MFN, it's likely that it's going to be money that is probably going to affect American interests. So I just wanted to say that's one area where this could be problematic.
Very interesting.
Can I just can we comment on each other's discussions?
Yes.
So on the human rights, humanitarian intervention, obviously that's not formally recognized in the UN Charter. It was developed after the failure in Rwanda and the response in Kosovo, and they developed principles. You could say they're extra charter principles, but they've sort of been recognized. The current situation wouldn't come to the genocide standard, I think, in Kosovo and Rwanda. So you'd have to be willing to debate an expansion of the humanitarian intervention arguments, to your point. On the consent issue, there's nothing in the UN Charter that talks about consent, but everyone knows it's a defense. It very, very clearly recognizes it as a defense. But because there's no text, it's sort of like developed over time through a variety of different cases. And so the most obvious examples where it might apply would be the governments in exile requesting consent to come in and help us. In World War II with the Germans and the Dutch, in the Gulf War with the Kuwaitis in exile, the Kuwaiti government was in exile. The Saddam Hussein was in Kuwait as the government of Kuwait, but the government of Kuwait in exile asked for assistance, and that was clearly a request for help, and that was consent. So that's the easy case. On the other case, the United States tried to argue in the Nicaragua case that we were invited by the Contras to come in and help, to overturn, and the ICJ said, no, that's not consent. That's not consent, right? So you'd have to make an argument that one of two things. One, that the Maduro, because he's not the legitimate head of state, cannot refuse consent, right? Is that possible? So it's not that, did Machado consent, but did Maduro have the freedom to consent, to refuse consent if he's not the legitimate head of state?
You need authority.
Yeah, exactly. I mean, the problem with it is it proves too much. Then anyone can go in. And then the other question would be if Machado and Gonzalez can consent, they clearly celebrated afterwards, but did they consent before, right? And that's a distinction that I think you would have to make. And then the final thing I would say is, like, look, Trump has all the cards right now. Golda Meir, in 3 months, got a settlement with Argentina. And what they need to do is have a communique of, like, resolution of the dispute and some sort of language to that effect, either with the current government or after there's elections, you know, with proper, you know, elections, and then with that government, get a communique and get a settlement. And I think we're going to be safe. And then the final thing I'll end on is Golda Meir's comments after the Eichmann case. I'm not claiming that this is a normal situation, but we are also not dealing with a normal case. And so this is a really special case. You know, so you're not going to get this kind of case repeated very often, I don't think. Any comments or actions?
Yeah, my only comment is I agree with the genocide thing. I don't think it leads to that level. I'm just thinking about probably crimes against humanity. That's the one that could.
I'm sorry, what did you say?
Crimes against humanity.
Against humanity.
Crimes against humanity.
Yeah, so definitely not a genocide level.
Well, I disagree with John on his interpretation of these opinions of the Justice Department. I think this is a very optimistic reading by John. And these opinions that I've read in Kosovo, Syria, a whole bunch of these, they say it's war if there is an extensive danger to our troops, an ongoing extensive danger to our troops. That's when it hits the war exception. Now, you know, that's what they say, and you know, they've been criticized for being slavishly obedient to the will of the president that has hired them in the Office of Legal Counsel, but that's what those opinions say. It's true that in some cases there was a kind of nexus to UN Security Council resolutions, but they didn't actually authorize the use of force in some cases. It was used as a predicate for the president's actions. So I actually think if we look at the corpus of these opinions and the practice of the United States, even though it irks me that this is the case, but actually the president can, in fact, intervene in these countries without congressional authorization. Now, I think there's a duty of consultation, as I said, and if it can't be done before, it must be done afterwards. I think there needs to be some coherent explanation from the executive as to what it's doing. I am actually troubled. I know Jide is a fantastic historian and lawyer. I am actually troubled if this is just an enforcement action on behalf of American oil interests. I mean, that brings us back to the gunboat diplomacy of the 19th century, McKinley and all that stuff, if that's the justification. This is either about drugs invading the United States, or it's about helping the recognized regime. And that's, you know, it has to be some sort of, it seems to me it has to be some sort of justification that makes sense even in the very broad national interest standard that the Office of Legal Counsel has articulated.
Are you going to moderate, or how do you want to?
You need the moderator.
Yeah, we can go questions.
Yeah, I think the floor is open for questions, but please use the microphone.
Fascinating panel. I have a question about sort of the relation between law and norms. I know everybody loves that. You know, I sort of see two sets of themes up here broadly. One's about pure legality, right? And one's about normativity. I suppose one question I have is there, regarding the international law legality of this, is there any limitation to the international response from the fact that, one obvious analogy would be Ukraine, but I'm also thinking of, for example, the Chinese aggression against the Uyghurs. Does that in any way condition an international response insofar as while a normative critique could be directed against Trump's intervention in other countries' domestic affairs, international actors will be constrained because it might force them to examine their own normatively questionable uses of sovereignty, right? It's vaguely phrased. I can phrase it more sharply if you want. But I'm curious. This is one thing I find truly extraordinary about this situation. The international law critique is very strongly framed in normative terms. But other than Ukraine, I see relatively few analogies to other normally questionable conduct that arguably violates sovereignty or international law against strong actors. I guess I'll phrase it more sharply.
That might work. That might work.
Yeah.
All right.
More specific.
Does the hesitancy of the international community to react against the U.S. in any way operate on terms of power, as well as on terms of norms? And I'm thinking, I did not realize there was such a close relationship between China and Venezuela on the basis of oil. Will China in any way be constrained by its desire to maintain an economic relationship with the U.S.? Will that constrain international markets? And the analogy I'm thinking with Ukraine is not merely about human rights, but also about the fact that cutting Russia out of the international economy is something that countries can do without crippling their own economic position. Will they be constrained to react against the U.S. only on the basis of power, but also on the basis of norms?
I do think that the Trump administration in this realm operates from a perspective of legal realism, rather than sort of an idea of liberal conformity to international law, liberal in the classical sense, and so I think what's happening is people don't feel like this is the same as Putin's invasion of Ukraine. It just doesn't feel the same at all, right? To almost anyone, and so why is that? And I think it's because everyone knows Trump's instincts are to do, calculated strikes and then back off, because he's criticized the Iraq war forever, and so you look at Soleimani, you look at the Iranian strikes on the nuclear strikes, and you look at these cases, and it looks like he has no interest in occupation and that's part of the reason I think that the opposition is not in power right now. He has no interest in occupation. And so I think that this just feels like a different situation than the Bush administration, I guess I would say.
So one member of the
respond to
panel
that?
had a concrete suggestion for what the administration ought to do now, and that was Roger, who, as I understand it, proposed that we should facilitate free and fair elections in Venezuela, and then conduct a settlement with the new legitimate government of Venezuela. And I felt like that sort of implied and otherwise treat that new government like a sovereign a government. And that actually sounds like a super sensible going forward strategy, but it doesn't sound like the sort of thing that Donald Trump is at all likely to actually do. And his early comments suggest that he does not have something like that in mind. He's going to run it. And so now it looks like they're investigating the possibility of setting up essentially a puppet regime using the remnants of Maduro's administration. And so what I'm curious about from any and all panelists who are willing to share it with us is, what is your prediction for the actual medium-term consequences of this decision to snatch Maduro?
I don't know what does President Trump has in mind, but I do have an idea of why they want to use the vice president instead of just calling to elections right away. I mean, narco-traffic is like everywhere in Venezuela right now. Like, the governors of the different regions of Venezuela are part of the cartel de soles. Like, they're part of cartels, drug cartels. So it's hard to just call to elections, put someone new, because the country is still governed not only by the vice president, but by all these other people and the military that has backed Maduro for
Especially the military.
Especially military that have received the money forever. So it might be easier to have this vice president that it's a Chavez and a Maduro follower for forever, managing the thing, receiving the instructions from the U.S., than putting someone completely from the position right now. That's one of my guesses, but I guess it's just a guess.
Here is a practical thought, and it would be really interesting to know if anybody in the administration is thinking about this. I expect somebody is, and what they're thinking. I don't know what the president meant when he said, well, we're going to war on Venezuela. But one question that, as I say, I hope somebody is thinking about is, at what point would continued U.S. involvement in Venezuela require a supplemental appropriation? That is, at what point does the U.S. military run out of the funds to conduct an operation like this out of sort of the ordinary appropriation that can be used for something that's quite brief. Because if you're wondering what is the point at which Congress might well get involved, it's if, I don't know that this administration would do this, but if they decide to try to do something that would require a supplemental appropriation to have that many boots on the ground.
Which I think is why the president is playing footsie with, is her name Gonzalez?
Yeah.
With Gonzalez, because he doesn't want to put significant boots on the ground here. Not for legal reasons, but because it will not play well politically. He has a semi-isolationist wing, to his movement there. So it seems that President Trump has never understood the notion of picking an achievable objective and achieving it. That's the sense I'm getting from a number of the initiatives that he has taken. So there's going to be something going on with the existing interim regime. And maybe there'll be some deal on oil, but I just don't see it at this point any change in the climate of democracy in Venezuela.
I was going to enter in just maybe a small point, which is not really medium term, is actually very short term, is that the indictment in New York actually has two other people who are affiliated with the regime. The current interior minister, who's considered to be part of the kingpin in the drug trade, and then a former interior minister who's also affiliated with the regime. I don't know what the theory is about how these people might be brought to the United States, or whether there's a sort of sense that this is going to be written off. But the reason I think this had to do with something Roger brought up earlier. He talked about like the overwhelming support that this intervention, might have brought to the Venezuelan people. But there's something that an outside observer, at least looking in, might be worried about, which is, despite all the pressure on Maduro for a very long time, there were very few defections by generals. And that suggests that some reason the regime loyalty of the generals is very high. Yep. Now, it could be for ideological reasons, or because they're all in the sewer and they realize that, like, if they don't have this regime to protect them, they're all going to be prosecuted. Maybe that's a possibility. But the fact that the generals are not defecting should really, really worry anyone who thinks that there's going to be anything smooth about this if you decided to remove the current regime.
All I know about this is what you five have said and what I've read in the newspaper.
Could you speak up a little bit? I'm sorry.
Yeah. So all I know about this is what I've read in the newspaper and what you five have said. So if I get this wrong on my question, I apologize. But I've read that there's a memo from OLC that was written by Bill Barr during the Noriega situation that says the president does not have to follow the UN Charter. Is there any merit to that position, if I got it right? That's one question. Question number two is, some of the theories that I've heard from the panel, there were crimes against humanity committed by the administration in Venezuela. The legitimate president consented. These theories depend on factual claims that have never been adjudicated. As far as I know, there's no adjudication that Maduro ordered a killing in Chile. There's no adjudication that Maduro did not win the election. These are surmises, very educated ones that we're making. What kind of standard of proof does international law or whatever law require before we go in on some factual premise?
So yeah, I read the Barr memo carefully in anticipation of this, because I think the Noriega example is the one that we're all going to be looking at for the prosecution. And he does say that. He basically says on page 178 of the copy I have that the UN Charter is not a self-executing treaty and therefore is not federal law for purposes of the United States Constitution, and therefore he's not, in the Take Care Clause obligations that the president has, he's not required under the Take Care Clause to follow the UN Charter. That doesn't mean that this president or any president doesn't recognize the importance of the UN Charter, Article 2, Section 4 on the use of force. It's just that the obligation that's triggered is not as a basis of the take care clause, it's probably other consequences of it. I think that would be the way I would think he is looking at that.
Let me say, I agree with what Attorney General Barr said yet in a sense, well, I agree with it, but the scope to which it's relevant is, I think, limited. Because I think it's true that the international law obligations of the United States is a party to the Charter, so it has obligations under the Charter, do not, as it were, automatic, this is part of what it means to say a non-self-executing treaty, do not flow through to create obligations of people in the US government, including Congress, which is, I think, the reason that I agree with Attorney General Barr's analysis is because I agree with the position that's been taken for a long time, going back to the 1790s, that Congress does not have a US domestic law obligation to implement the international law obligations of the United States. I think that Congress is usually well advised to do so, but I think Congress doesn't have to do so. And sometimes Congress acts so as to put the United States into violation of its international law obligations. I think when Congress does that, the result is that was valid under US domestic law, provided Congress exercises power that it has, and now the US is in violation of its international law obligations. That's a result of sort of what's called dualism, the way the US domestic legal system and the international legal system work together. I think the same reasoning that applies to Congress applies to the president within whatever is the scope of the president's authority, which people differ about. I think that it's more constricted than a lot of people think. But one thing I will say is that insofar as the president's authorities depend on statutes and on implications from statutes, I think it's a sound principle of statutory construction that Congress expects that the United States is going to comply with its international law obligations, and in particular is going to comply with the Charter, which has been sort of a foundation of US foreign policy from the standpoint of both Congress and the president since the United States became a party to the Charter.
I'm fearful of being misinterpreted what I just said, so I want to make it crystal clear. He is bound by the UN Charter, but the binding is at the international plane. The fact that it's not a self-executing treaty means he doesn't have the same level of obligation at the federal level in his execution.
These are obligations on the United States as such.
The United States and not the
remedies
president or
are
Congress.
political, or if they're international tribunals, which I think would be problematic if imposed against.
One little caveat, I mean, this is not, because I disagree with anything that he said, but this is sort of like what would be the legal argument against this. The legal argument that folks would make against the Barr memo with respect to the self-execution. They would say if Congress did not pass legislation making it self-executing, what that means is that that's a constraint on the judiciary. That is, the courts will not be able to use the articles of the Charter and treat them as self-executing, but it would still bind the president. That would be the argument. So the claim would be that the president's still violating this. It's just that the courts will not be able to invoke.
So yeah, there is a version of the non-self-execution concept that goes to what the courts can do as opposed to having any domestic law consequences whatsoever.
Right. And I just want to add one thing about the adjudication aspects. There are some decisions of the Inter-American Court of Human Rights against Venezuela. Of course, Venezuela hasn't complied with them, but that establish the violations of the human rights and the facts. So, and the International Criminal Court, I don't think there's a judgment yet because, of course, they couldn't bring him to the Hague, but there is a case there also against the Maduro regime.
Is Venezuela a party to the ICC?
Yes, it is.
Is it?
Yeah, it is.
Can I ask a quick follow-up question? Because again, I'm ignorant on all this. How do we know if a treaty is self-executing or not self-executing?
It's a good question.
John, you can take that. That's like, that is like international law 101, but it's not an easy answer. I tell you that.
I would say that's a question of the meaning of the treaty, because we know treaties can be self-executing. They can have U.S. domestic law consequences. Article 6 indicates that, and the Supreme Court occasionally runs into this, and they sort of mumble something and don't say anything really systematic. But the high-level answer is that's a question of the meaning of the treaty.
Sometimes, like extradition treaties, they'll say in the communique or in the declaration that this is a self-executing treaty. But otherwise, the courts have to interpret it and crystallize whether or not it is. And sometimes some of the provisions are, and sometimes other provisions are not.
I think if you read carefully Medellin, the Supreme Court decision Medellin, they've cut back on the concept of self-executing treaties. I agree it's a treaty interpretation question, but there's a heavy thumb on the scale after Medellin.
There was one.
Eugene had a question. I was dying for Eugene's question. Like.
It was the same one for me, and I had not fully answered.
What do we?
Maybe there is no full answer.
Yeah, exactly.
But I was going to say something quickly about Professor Fitzpatrick's argument about when was this adjudicated with respect to who is or not the
Legitimate head of state.
The legitimate head of state. I mean, just as the domestic law analogy here is that the president's determination of these things is owed deference. So, like, if the president says the legitimate head of state is so-and-so, based on their power of an organ of communication with foreign countries and recognition powers, the assumption is that courts would defer to that judgment. So if this came up in litigation, President Trump's judgment about who the legitimate head of state would be owed deference, I guess, is...
It would be a high degree of deference if I read Zivotofsky correctly here.
I think the background principle in all of this is the world safer when you are doing these sorts of actions or not? I mean, that to me is what really is animating a lot of these questions, not whether it's legal. And so, can we say that you go down the list of activities, the strike on the Iranian nuclear facility was maybe anticipatory self-defense, but probably not. And yet the world feels safer because of that. The attack on Soleimani, the Iranian military leader that was, the state sponsor of terrorism, is the world safer after that? Well, we could say it was legal because of the war on terror, and he's a principal terrorist, so it's probably a legal strike. But the world definitely feels safer after that, right? And so I think the calculation in the end, really, for a lot of these people in the military and in the administration would this facilitate international peace and security, which is ultimately the goal of the UN Charter?
I think we also have to worry about how this plays in Latin America, because people like Gonzalez and her father, they were radicalized by American moves in Latin America. So
that's a good point.
That's not a legal point I'm making, but it's a constraint that has to be borne in mind.
And you alluded to this as well. I mean, obviously we can be somewhat hopeful right now, but I was somewhat hopeful after the Arab Spring, and look what happened to that.
Right.
That was not a great ending to the Arab Spring in almost all of those countries.
Right.
I don't know if you have time for one more brief question, which is only barely a legal question, but does it change any of your analyses if the Trump administration never makes any moves to put Edmundo Gonzalez into power or hold elections or anything along those lines?
I think they're trying to do that at the right time, but you've alluded to all of the obstacles of doing it too quickly. That's my impression.
It would change my position in favor of the intervention, because I think if we agree that we can do this only for police reasons, well, we will have to agree that the military of any country can go to any country to execute an arrest warrant.
Arrest warrant for anything.
And
that feels too much.
That feels too much, yeah. That feels too much. So it has to be something else, because that feels too much.
One thing I was going to say with respect to that, though, is that if you look at the indictment, it gives you the background of Maduro. And yes, I concede that there are going to be other people in indictment, including the interior minister, who look like they were really bad actors. But one argument one could make is in the current regime, Maduro was a particularly bad actor. I mean, his involvement in being in conspiracy to import drugs happens before he was appointed. As a foreign minister, he was providing diplomatic passports to people and providing apparently diplomatic cover so that they could smuggle drugs. So what I'm just trying to say is that regardless of what you think of the regime structure, maybe removing Maduro from the picture in itself may help wean them off what I would call this excessive dependence on drug traffickers, because he himself was a really big player in that. I don't know if that's helpful, but it's minor, but it says if we can get him out of the picture, maybe there's hope.
Thank you.
Thank you very
Thank
much.
you.
Annual faculty conference. I do want to just say one word of thank you to all of our panelists for really a